नमस्कार दोस्तों, हम कर रहे हैं इंटरप्रिटेशन ऑफ स्टैट्यूट्स की सीरीज़ और जिसमें हम कर रहे हैं एक्सटर्नल एड का पार्ट 4 जिसे हम कह रहे हैं टेक्स्ट बुक। और आशा करते हैं कि आपको हमारे लेक्चर्स पसंद आ रहे हैं और यदि आपको हमारे लेक्चर्स पसंद आ रहे हैं तो आप हमें यूट्यूब पर ज़रूर फॉलो करें। तो देखिए दोस्तों, जो टेक्स्ट बुक है अगर उसका डेफिनेशन देखें, टेक्स्ट बुक इज जनरली डिफाइंड एज ए बुक यूज्ड एज ए स्टैंडर्ड वर्क। It is a standard work for the study of a particular subject, especially one used in schools, colleges और यूनिवर्सिटीज़। यानी कि जो स्कूल, कॉलेज और यूनिवर्सिटी में हम पढ़ते हैं, जिससे किसी पर्टिकुलर सब्जेक्ट की एक किताब होती है जिसे हम टेक्स्ट बुक कह रहे हैं। और लीगल डेफिनेशन की अगर बात करें, लीगल इंटरप्रिटेशन में बात करें, तो इट इज़ एन एकेडमिक और स्कॉलरली पब्लिकेशन रिटन बाय एन एक्सपर्ट और अथॉरिटी। यानी कि जिन व्यक्तियों का उस फील्ड में नाम होता है या जिन अथॉरिटी मानते हैं, एक्सपर्ट मानते हैं, उनके द्वारा लिखी गई कोई स्कॉलरली पब्लिकेशन को हम टेक्स्ट बुक कह रहे हैं। इट इज़ यूज्ड फॉर एजुकेशनल पर्पजेज ऑफ कोर्स एंड ऑफन साइटेड एज ए सेकेंडरी सोर्स टू एक्सप्लेन, एनालाइज और कमेंट ऑन स्टैट्यूट्स एंड लीगल प्रिंसिपल्स। मान लीजिए कोई पर्टिकुलर लिटरल रूल के ऊपर, मान लीजिए जस्टिस जीपी सिंह की किताब को, जैसे मैं बाइबल कह रहा हूँ लीगल इंटरप्रिटेशन की, तो अगर वो कुछ कह रहे हैं तो इट बिकम्स सेकेंडरी सोर्स टू एक्सप्लेन, एनालाइज और कमेंट ऑन ए पर्टिकुलर स्टैट्यूट और स्टैट्यूट्स और लीगल प्रिंसिपल्स। नाउ की कैरेक्टरिस्टिक्स ऑफ ए टेक्स्ट बुक, लीगल कॉन्टेक्स्ट में बात कर रहे हैं। नंबर 1, इट इज़ ऑथर्ड बाय लीगल स्कॉलर्स और एक्सपर्ट्स। Number 2, it is structured and comprehensive because it covers a systematic explanation of a particular subject. It is educational because it is used in legal education and often prescribed in the syllabus of a particular subject. It is a secondary source of law because it provides commentary. It is not a law itself. Secondary source क्यों कह रहे हैं? क्योंकि ये खुद कानून नहीं है बल्कि कानून की व्याख्या करता है। नंबर 5, it has a persuasive value. It is used by courts to understand or explain legal issues. Now, textbooks are valuable external aids in statutory interpretation. They help judges make informed decision, right? Especially in complex constitutional or theoretical legal questions. Now, examples in legal usage: when courts face ambiguity in statutory provisions, they may refer to a well-known textbook like Principle of Statutory Interpretation by Justice Z.P. Singh and Constitutional Law of India by H.M. Sirvai. Now, there is a particular important aspect that textbooks are not binding, but they serve as a persuasive aid due to their scholarly credibility. And textbooks are not authoritative; they are opinions. However, they are scholarly. Now, the courts prefer primary sources like the statute itself, precedent, legislative debates. A textbook's influence depends on the author's reputation and in-depth analysis of a particular subject. So, basically, the whole thing revolves around the reputation of an author. Now, what is the role of textbook in interpretation? It has authoritative explanation. Textbooks written by reputed legal scholars often provide detailed explanations, detailed analysis, and detailed interpretations of statutory provisions. Now, courts may consult these to understand the broader context or technical meaning of certain legal terms. A clarification of legal principles. Number 2, when a statutory provision is ambiguous, textbooks can clarify general legal principles or doctrines that inform the statute's meaning. Number 3, historical and doctrinal background. Textbook can trace the historical evolution of a statute or legal principle, providing insights into its original intent and application. Number 4, comparative perspective. In some cases, textbooks compare laws across jurisdiction, offering useful analogies or interpretations when domestic law is silent or unclear. Now, in case when the domestic law is silent or unclear, the courts can refer to the textbooks to compare laws across different nations and to use those analogies or interpretation to explain the domestic law further. Now, judicial recognition as far as concerned, Indian courts have occasionally referred to textbooks, especially by renowned authors, as persuasive aids. However, they do not have binding authority, it has become quite clear. Now, courts use them to support their reasoning, not to substitute statutory text or establish precedent. यानी कि ना तो लिखे हुए कानून को और ना बनाए गए सुप्रीम कोर्ट द्वारा बनाए गए कानून को या हाई कोर्ट द्वारा बनाए गए कानून को कोई भी किताब सब्स्टिट्यूट कर सकती है. लिमिटेशंस क्या हैं? टेक्स्ट बुक रिप्रेजेंट पर्सनल ओपिनियन ऑफ ऑथर्स एंड मे बी बायस और आउटडेटेड. नंबर 2, they are not primary sources of law and should be used with caution. Number 3, courts generally prefer internal aids like preamble, headings, definitions, and primary external aids like legislative debates, historical context over textbooks. Now, if we analyze case laws, K.P. Varghese versus Income Tax Officer, reported in All India Reporter, 1981, Supreme Court at page 1922. The facts were the K.P. Varghese, the assessee, sold a house property, and the income tax officer sought to add an amount to the declared consideration under Section 52, Clause 2 of the Income Tax Act 1961 on the assumption that the sale price was understated. The issue was whether Section 52, Clause 2 could be invoked merely on the basis that the fair market value of the property exceeded the declared sale price without any evidence of understatement or actual receipt of a higher consideration. यानी कि मार्केट वैल्यू से कम में बेच दिया और जो डिफरेंस था उसको इनकम टैक्स ऑफिसर ने इनकम में जोड़ के इनकम टैक्स लगाने की कोशिश की है. Now the judgment was the Supreme Court ruled in favor of the assessee, holding that Section 52 Clause 2 can't be applied in absence of concrete evidence that more than the declared consideration was actually received. It was emphasized that taxing provisions must be construed strictly, and a mere disparity between market value and the declared sale price does not justify invoking the section. यानी कि अपनी प्रॉपर्टी को कम बता के और बेच दिया और अगर कोई अमाउंट ब्लैक में रिसीव की है तो ऑफेंस बनता है, और अगर यदि नहीं की है तो कोई ऑफेंस नहीं बनता है. की लीगल प्रिंसिपल क्या है अगर हम बात करें? द कोर्ट्स हेल्ड दैट वेयर स्टैट्यूटरी लैंग्वेज इज एम्बिगुअस और ससेप्टेबल टू डिफरेंट इंटरप्रिटेशंस, external aids such as authoritative textbooks, legislative history, committee reports like select committee or law commission reports may be referred for understanding the true intent of the legislature. In this case, the court utilized such materials including recognized legal commentaries to conclude that Section 52 Clause 2 was meant to target only the cases involved actual concealment of consideration, not mere market discrepancies. Significance of the case is that it is a landmark in statutory interpretation, affirming that legitimacy of using textbook as interpretative tool when statutory provisions are not clear, thereby promoting a just, fair and reasonable application of tax laws. Case Law 2, State of Karnataka vs. Union of India, reported in All India Reporter 1978, Supreme Court at page 68. Very important case it is. Facts were that this case involved a constitutional challenge by several states, including Karnataka, to the power of union government under Article 356 and related provisions of Indian Constitution concerning the centre's control over the states and the functioning of federalism in India. Issue was that the central issue was whether the union government's authority to send commissions to investigate the state governments under Article 356 and Article 365 violated the federal structure of the Constitution. The judgment was the Supreme Court upheld the constitutional validity of Union's power, interpreting the Constitution as establishing a quasi-federal structure rather than a purely federal one. It held that the Union does have limited power to ensure that the proper functioning of state governments. Key legal principle is that use of textbook. In this case, the court expressly acknowledged the importance of academic commentaries and legal textbooks in understanding the evolution of constitutional doctrines such as federalism, parliamentary supremacy, and emergency powers, the meaning and context of legal terms, and provisions that are not self-explanatory, the comparative perspectives from other constitutional systems like USA, Canada, and Australia. The court used these academic resources as external aids to interpretation when the constitutional text was ambiguous or required deeper historical and theoretical insight. The significance of the case was that the decision reinforced the judicial openness to scholarly opinion and textbook analysis in constitutional interpretation, especially in cases involving abstract principles like federalism, separation of powers, and constitutional morality. Case Law 3, Bharata Mutt versus R. Vijaya Ranganathan, year 2010, Supreme Court 2685. The facts were the dispute arose over the inheritance rights of children born outside the wedlock, that is, illegitimate children, under personal laws, especially regarding whether such children could inherit ancestral property or only self-acquired property of the father. यानी कि जो इलिजिटिमेट चिल्ड्रन हैं, क्या वो जो हम दादा लाई प्रॉपर्टी में हक होगा या केवल पिता की कमाई संपत्ति में हक होगा. इशू वेदर चिल्ड्रन बोर्न फ्रॉम ए रिलेशनशिप आउटसाइड द लॉफुल wedlock are entitled to share in the ancestral property of the father under Hindu law. Judgment was the Supreme Court held that illegitimate children are entitled to inherit only the self-acquired property of their parents and not the ancestral co-partitionary property. This interpretation was consistent with earlier judicial precedents and the principle laid down in Hindu law. The key legal principle, use of textbook. The court relied on legal commentaries and authoritative Hindu law textbooks such as those of by Mullah and Mane to clarify the scope of inheritance rights under Hindu law. These resources, they were used to explain the legal status of illegitimate children under traditional Hindu law and statutory modifications, and differentiate between co-partitionary and self-acquired property in terms of inheritance rights, clarify ambiguous statutory provisions in the Hindu Succession Act 1956. The court reaffirmed that the textbook written by authoritative legal scholars serves as important aids in interpreting personal laws, especially where statutes are silent, ambiguous, or rooted in customary law. Significance of the case, that this case illustrates how the judiciary relies on legal scholarly textbooks to interpret different important areas of personal law, particularly when dealing with socially sensitive issues like the rights of children born outside the wedlock. It reinforces the role of academic opinion in shaping judicial understanding of traditional doctrines in modern context. Now, case law for Shivkant Yadav versus Indian Airlines 2005 का केस है सुप्रीम कोर्ट का. Facts were that Shivkant Yadav, an employee of Indian Airlines, challenged his termination from service, alleging to be it is unjust and in violation of procedural safeguards under the Industrial Dispute Act 1947. The case involved interpretations of provisions relating to retrenchment, reinstatement, and the definition of workman under the Act. Issue was whether the termination of Shivkant Yadav amounted to illegal retrenchment under the Industrial Dispute Act and whether he was entitled to reinstatement or compensation. The judgment, the Supreme Court ruled in favor of Shivkant Yadav, holding that the termination was not carried out in accordance with the mandatory procedural requirements. Under the Industrial Dispute Act, the court emphasized that due process and statutory protections afforded to a workman under the Act were not followed. The key legal principle, to interpret the scope and application of terms like retrenchment, workman, and termination, the court turned to authoritative commentaries on labor and service laws, including treatises and textbooks on industrial and labor law by scholars such as O.P. Malhotra, H.N. Mishra, and others. Academic analysis that provided historical context and technical interpretation of labor legislation. These material helped the court in clarifying technical definitions under labor law that are not self-explanatory from statutory text alone. Understanding the intention behind the protective provisions of the Industrial Dispute Act, applying settled labor law principles to ensure equity and justice in employment matters. As far as significance of the case is concerned, it highlights the judicial reliance on legal textbooks and academic commentaries in interpreting complex and technical provisions in labor legislation. It reaffirms the role of legal scholarship in bridging the gap between statutory language and practical application, especially in socially impactful domains like employment and industrial relations. Case Law 5, Keshwan Bharati vs. State of Kerala, EIA 1973, Supreme Court 1461. largest ever bench constituted in Indian history, and the date of judgment was April 24, 1973. It included 13 judges. Keshwan Bharati, the head of religious mutt, Adenir Mutt in Kerala, challenged the Kerala's government attempts to impose restrictions on the management of its property. Under the Kerala Land Reforms Act 1963, the case escalated to a challenge against the extent of Parliament's power to amend the Constitution, especially fundamental rights under Article 368. The issues were whether the Parliament has unlimited power to amend the Constitution under Article 368. Can fundamental rights be abridged or taken away by constitutional amendment? And number 3, does the Constitution have a basic structure that can't be altered? 7:6 majority held that Parliament can amend any part of the Constitution, including fundamental rights, but it cannot alter the basic structure or essential feature of the Constitution. The doctrine of basic structure, this doctrine established in this case, became a landmark in Indian constitutional law. It reinsures certain fundamental features of Constitution like supremacy of the Constitution, rule of law, separation of powers, judicial review, and fundamental rights. Now these they can't be abrogated even by constitutional amendment. The significance of the case was that limited Parliament's amending power to preserve the constitutional core values. Overruled Shankari Prasad 1951 case and Sajjan Singh 1965 case to the extent that they gave Parliament unrestrained power. Upheld Golaknath versus State of Punjab in separate but not in form by allowing amendments with the caveat of the basic structure doctrine. Now, role of textbooks in interpreting constitutional provisions and understanding the nature of constitution. Judges referred extensively to legal textbook, constitutional assembly debates, and comparative constitutional law. Key points on use of textbooks were: number 1, authoritative commentaries. यहाँ पे थोड़ा ध्यान से देखना है दोस्तों में. Judges including Justice H.R. Khanna and Chief Justice S.M. Sikri cited prominent constitutional law treatises like those by V.G. Ramchandran, Cole, and Dicey to illustrate the meaning of terms like amendment and constituent power. Comparative jurisprudence reference was made to how other jurisdictions like US, Canada, and Germany treated constitutional amendments using scholarly texts to support reasoning. Doctrine formation. The basic structure doctrine itself was shaped by scholarly analysis present in the legal literature and textbooks, including how constitutional principles evolve through both judicial reasoning and academic insights. Key textbook and authors cited in Keshwan Bharati. Judges referred extensively to academic texts, treatises, and writings of constitutional scholars, especially from India, UK, and US. Sir Ivor Jennings, Law of Constitution on Parliamentary Sovereignty and Constitutional Law. Wade and Phillips, Constitutional Law for Comparative Constitutional Interpretation. A.V. Dicey, Introduction to the Study of Law of the Constitution, especially on the doctrine of parliamentary sovereignty and the rule of law. Sirvai, Constitutional Law of India. H.M. Sirvai was heavily cited for his authoritative views on Indian constitutional law. Austin's The Indian Constitution, Cornerstone of a Nation. Now, Grenville Austin's work was referred to understand the philosophical underpinnings and historical context of the Constitution. Significance of the case was that Keshwan Bharati versus State of Kerala is the cornerstone of Indian constitutional law. It preserved the identity of the Constitution by introducing the basic structure doctrine, ensuring that no authority, including Parliament, could distort to its foundational principles. The case also demonstrates the judiciary's willingness to engage deeply with the academic writings and legal textbooks to interpret complex constitutional issues. Conclusion: the use of textbooks as interpretative tools has been acknowledged in Indian jurisprudence, although not a primary source of law, but textbooks, they are persuasive and often cited where a statute is ambiguous or silent, legislative history is unclear, there is a need to understand doctrinal or theoretical underpinnings. तो आशा करते हैं दोस्तों आज का लेक्चर आपको पसंद आया होगा. आप हमें एक्स पर, इंस्टा पर और फेसबुक पर डॉक्टर अनुपम आचार्य के नाम से फॉलो कर सकते हैं. यदि आपको वीडियो पसंद आए तो इसको लाइक करिए, शेयर करिए और नोटिफिकेशन आइकन को दबाना ना भूलें, और साथ साथ में चैनल को सब्सक्राइब भी करके जाइए. आप हमारे पेज डॉक्टर अनुपम आचार्य नंबर 1 मोटिवेटर एंड ऑथर को भी फॉलो कर सकते हैं. थैंक यू दोस्तों.